Good morning, everybody. Thank you for joining. My name is Sean Coffey. I'm the Communications Director here at the California Policy Lab. We are excited to talk about the PARR program with you today and the research findings. We will have a presentation from our speakers, and then we'll have time at the end for questions. If you do have questions, you can type them in the Q&A box, and we will share those with the speakers. I'll start with a quick introduction of the two organizations and then the speakers. The California Policy Lab is a nonpartisan public policy research institute. We are headquartered at the University of California with sites at the UCLA and UC Berkeley campuses. We partner with state and local government agencies like the Public Defender's Office to translate research insights into government impact. We do this by creating long-term partnerships with government agencies to perform rigorous research and to help improve programs and policies that impact millions of Californians every day. The County of Santa Clara Public Defender's Office provides vigorous, high-quality representation to low-income clients in the criminal and civil courts in Santa Clara County. The office is led by Public Defender Molly O'Neill, has approximately 240 employees. The PARR program, which we will be talking about today, served over 1,300 people last year. On to our speakers. My colleague, Dr. Joanna Lako, is the Research Director at the California Policy Lab's UC Berkeley site. She has partnered with the Public Defender's Office since 2019 to demonstrate the impact of the PARR program. She also leads other research focused on reforming the criminal justice system, including research on the statewide implementation of the Humphrey decision, multiple reports to support the work of the California Committee on the Revision of the Penal Code, as well as research focused on high utilization of criminal legal health and housing services in San Francisco. Charlie Hendrickson is a deputy public defender at the County Santa Clara Public Defender's Office. He was part of the team that worked on the early representation team, which evolved into the PARR program, and he continues to work with the PARR team today. Carly Warehorn helped to design, launch, and oversee the PARR program while at the Santa Clara County Office of the Public Defender. She served as a public defender for 14 years and currently serves as the clinical supervising attorney at the Criminal Defense Clinic at Sanford Law School, where she is also a lecturer. Megan Piano has been with the County of Santa Clara Public Defender's Office for 15 years. She directly worked with people in the PARR program for over a year and is currently the supervising attorney for the PARR program, where she leads the team of PARR attorneys. With that, I'm going to turn it over to Charlie.
Thank you so much, Sean, and it's really a pleasure to be here with Joanna and Carly and Megan. And Carly, it's great to reconnect with you, and now that you are in your new assignment in Stanford. The PARR program kind of came up organically, and it was really done in response to a decision called In re Humphrey, which came out in 2018, which really changed the landscape for people in pretrial detention. Previously, people who were, charged the crime, their bail was usually set reflexively by the courts according to a bail schedule. And PARR, or the Humphrey decision, essentially changed that. It said that each individual appearing in arraignment had the right to have an individualized determination as to their ability to pay bail, and also whether or not any less restrictive alternatives existed to incarceration. And when we read that opinion, we realized that that really was changing the landscape for people in pretrial detention pending trial. So we changed our model and decided that we really needed to start doing bail motions for those folks. But what really came out of that was an understanding that we really couldn't do that work without first engaging them really seriously as the individuals and human beings that they are, and understood their life circumstance, connectivity to community, whether or not they had dependent adults in the home, children, all those things, and whether or not they had stable employment. So this program kind of arose out of that, and it really does address the harmful effects that occur when people are incarcerated, even for short periods of time. Studies have shown that people who are incarcerated for as little as 48 to 72 hours can lose stable employment, housing, and custody issues, a whole variety of downstream effects, which really destabilizes our community. So in response to that, we were doing the bail motions. We also got connected with Civil Rights Corps and Alec Karakatsanis, who was doing a lot of this work and really spearheading it. And then that led us to the San Francisco public defender's office, who was actually doing early representation. They were the first county in Santa Clara to do it, and we modeled our program after theirs. We were very fortunate that we had a board of supervisors in Santa Clara County, particularly Supervisor Chavez, who was interested in this, and we were able to put together a legislative file to get some funding and start an initial program. And that initial program featured 2 lawyers. It was Carly Ware and her partner, Carson White, who was provided to us through some grant funding. And they really became the kind of the brains and the heart of the operation and got it implemented. So next slide. Thank you. Carly.
Thank you, Charlie. So I'm here to talk about how we intervened in kind of the day-to-day routine of the machine of what is booking and arraignments. So what we did with this precious funding is we built a team. It had 1 lawyer, 1 fellowship attorney. I was the lawyer, and Carson White, as mentioned, was the fellowship attorney. We also had a paralegal, an investigator, a social worker, and a district attorney had been funded as well across the street. So what we did with that team is we really tried to intervene and kind of just shine light into what I see as really like a black hole, which is the jail processing function that happens right after arrest. And what we did with that light is we just tried to kind of infuse that space with defense advocacy. The tasks that we did during that period of time after arrest and before arraignment are really the same things that we already do when we're representing a client. We just did them earlier. So we did things like send an investigator out to see if there's video of the incident. As simple of a task as just calling home and seeing if our client could be released, who could pick them up, and where they could live. Did they have transportation? Where's their car parked? Where are their keys? Oftentimes it's the downstream effect of these small details of the interruption of their daily lives that have profound effects and really detrimental effects on community and just on people's lives. If I could have the next slide, please. I want to talk about the time frame that we were working. So this slide is a graphic representation of the relatively unpublicized time after someone is arrested. So the first orange box is what's considered a booking, and that's when police will, take someone that they've arrested from their police car and kind of drop them off and transfer custody to the county jail facility. At that point in time in Santa Clara County, what happens is very automatic. The police write down something called booking charges, and then a magistrate judge that's usually kind of on night duty and is usually working remotely will kind of look at the computer and see what the charges are and are they supported by a probable cause affidavit. And if the judge believes that the arrest was sound and supported by the low standard of probable cause, the judge will set cash bail based on the pre-approved county bail schedule. And then a waiting period happens. That waiting period is governed by the penal code. And it's a weird time period because it's 48 hours of court being in session if court was in session at the time of the arrest. So if an arrest happens on a Friday after hours, it can be 6 days because the weekend doesn't count. And if there's a holiday on a Monday, that doesn't count. Wednesday is arraignment day. So what we did is we created a process by using the booking lists. And that process is represented by the gray boxes that are in the center bottom of this slide. We tried to figure out who was coming to court in the next couple of days and just simply connect with them and talk to them while they were in custody. We sent ourselves, the attorneys, in to talk. We also sent investigators in to talk with our clients that are part of the defense team. It was a confidential, private conversation. And I just want to give a couple of examples of some outcomes that came from that type of work of connecting so early with our clients. I had a client who was in the very early client pool of our pre-arraignment representation group, and he cut hair as a living. He was a barber. I was able to connect with his boss, which is a small barber shop. He had worked there for years. And no one had known that he was arrested. He had gotten in a dispute with his roommates. He was accused of assault with a deadly weapon. The deadly weapon was like a towel rod or like a curtain rod that had a spring in it and could kind of extend across a doorway or a shower opening. There were no serious injuries. He was booked on a felony. He couldn't afford the bail. I was able to connect with his employer, and at arraignment, I appeared with him after speaking with him in jail during that time he was arrested. And he was released at arraignment. We were able to resolve the case for a misdemeanor. He was able to return to his job. And then I took my son in the next couple of weeks to get his haircut. And I think that encapsulates the essence of what the pre-arraignment program tries to do, which is we treat our clients as the members of community that they are with us. I know Megan Piano had a case more recently. She's the current supervisor of this team. I remember she had a case where she connected with a client pre-arraignment. It was a dispute that happened in a laundromat, like a coin-operated laundromat. Our client was in jail and had been booked on assault of the other person, but we were able to secure evidence showing that the other person, the accuser, actually started the physical dispute, and our client had acted in self-defense. Megan sent an investigator, within hours of this incident, obtained the surveillance video from the coin-operated laundromat, convinced the district attorney to watch it over the lunch hour, and got the case dismissed at arraignment. So those are the type of results that we have seen in practice.
Great. Thank you both so much for that overview and those examples. So I'm going to talk about the study that we embarked on together. So I, as Sean mentioned, started working with this great team of people down in Santa Clara in 2019. And it became clear from the very beginning when they were thinking about the PARR model that they wanted to set it up in the way that would facilitate a research study that would allow us to learn what the impacts of the pilot program were. And so we set up a research partnership over the next couple of years that allowed us to figure out what the research design would look like and to carry out the study. And so the primary research question is, what is the impact of early representation services offered through PARR on release at arraignment, charge filing, and case outcomes for felony defendants? And so in thinking about how to implement the pilot in a way that would facilitate research, it became clear really early on that PARR didn't have the capacity to serve everyone in Santa Clara County who was going to be eligible for services. As you heard, they had 2 attorneys, a fairly small staff to serve all of the people coming in the door. So to fairly allocate resources, we decided together that the PARR unit would provide services 1 day a week and rotate that service day across days of the week, following a set schedule that we all decided at the beginning. So this meant in the first week, it was people booked on Monday, would be eligible for PARR services. In the second week, it would be people booked on Tuesday, as a kind of stylized example. As a result, this means that the PARR days and the kind of offer of PARR services is essentially random. So people who just happened to be booked on a day when PARR was being offered were eligible to receive PARR services, and people who just happened to be booked on a day when PARR wasn't being offered just got public defense services as usual. So in the evaluation, then, we're able to compare outcomes between those people who are booked on PARR treatment days and people who are booked on other days in the same week. And we look at people booked within that same week. Further, even on PARR days, the PARR attorneys weren't able to serve everyone who they put on that initial list as being eligible for PARR services. So when we estimate the impacts of the program, we're actually using a 2-stage model that allows us to get at the causal effect of participation in PARR on individual outcomes. And this really allows us to compare people who received PARR services after being booked on a PARR day to people who would very likely have received PARR services had they been booked on a PARR day, had they just been booked on a different day of the week. So to carry out this study, we use data from the Santa Clara County's case management system, CJIC, and this is information on bookings, case details, and demographic information from people involved in the system. We also use data from the Santa Clara Public Defender's Office on the specific types of services received by clients. Importantly, all of the data are de-identified when we receive it. We're able to link the data together, but we don't see any identifying information. The primary outcomes that we consider in the study are release from detention and the time to release, whether or not the case is dismissed, whether or not there's a conviction in the case, and whether or not there's a plea deal accepted. And when we're defining the sample, we tried our best to replicate PARR's eligibility criteria because we want to compare people eligible for PARR on PARR days and people eligible for PARR on non-PARR days. So that means we included all individuals who were booked into jail on a felony charge who were not released within 24 hours. And then we omitted cases that we knew wouldn't be eligible for PARR services on any day, including cases involving manslaughter or rape charges. So during the pilot period, which started in January of 2020 and then ended abruptly on March 13th, 2020 due to the court closures, 600 people were booked who appeared eligible for PARR. 101 of those people were booked on PARR days and 40 people received services. Okay, so one of the most important things that we do first is to make sure that the study design kind of happened in the way that we expected it to. Here we're expecting people who are given the opportunity to participate in PARR were effectively randomly selected relative to folks who were not given the opportunity to participate in PARR. And what we find is that people booked on PARR and non-PARR days are very similar across all of the observable characteristics that we see in the data. And for example, when you look at these descriptive statistics, you'll see that over half of the sample in our study are Hispanic. The vast majority are male. And the charge types that people are booked on are pretty evenly split between person offenses, property offenses, and drug offenses, which is about a third in each of those categories. So what did we find? First, we find that PARR participants spent less time in jail. So this is the number of jail days, both pre and post-trial, because that's what we observe in the data. But we find that the average person who received PARR services as a result of being booked on a PARR day spent 6 total days in jail, whereas comparable people who were booked on non-PARR days spent 29 days in jail. So this represents a 79% reduction in jail time for PARR participants. And how does this translate into case outcomes? So we find that receiving PARR services reduced the probability that an individual is convicted in the case that they were booked on by 27 percentage points, or about 75% relative to comparable people who were booked on non-PARR days. In addition, we find that PARR participants were 36 percentage points more likely to see their cases dismissed by the prosecution than non-PARR participants. There are 2 potential mechanisms that we identified that might be driving these results. First, faster pretrial release could lessen the need for an individual to take a plea bargain to secure their release. So that could be driving some of these results. And further, PARR attorneys may just be better equipped to mount a strong defense with more preparation. Specifically in the example that Carly gave, if you start the investigation early, there may be evidence that you can gather that bolster the case that could lead to the case being dropped or lower the likelihood of conviction. So in conclusion, the PARR pilot resulted in improved release and case outcomes for participants. It really suggests that offering public defense services as early as possible really can make a difference for low-income clients. We think this model could be adopted widely by other public defender offices in California and beyond our state, but it really takes a willingness to rethink how you engage with clients and how you structure the caseloads for those attorneys, as you hear Carly talk about the work they did. And we're excited to continue our work with Santa Clara. There are a bunch of questions that we still have about just why PARR is so successful at improving case outcomes. We'd love to do further, future work where we can serve more people and include more people in the study, and not have a global pandemic shorten our study. And there are a lot of questions that we'd still like to explore, such as do connections with social workers and kind of other support services really make a difference in outcomes? Really dig into the role of the plea deals and if that's driving a lot of the results that we see. And potentially even look farther downstream at recidivism and re-engagement in the criminal legal system. So there are many people that we'd like to thank for their help in kind of the initial setup and vision of the PARR program. We'll just put these here. And we point you to our policy brief and a longer, much more technical working paper that are all available through our website if you want all the details. And we want to recognize that the research study that we're talking about today was made possible through funding from JPAL, and we're really appreciative of that support, as well as all of the funders that support the California Policy Lab.
Thank you, Joanna. And then Charlie or Megan, it looks like we have time. If you all want to share a little bit about how the program has evolved since the pilot, that'd be great, or we can jump into Q&A.
Sure, I think I can give just a minute or two on that. So since the initial PARR launch with Carly and Carson White, we were really pleased with the results from that initial pilot program. And we realized that that was kind of a boutique practice or a small practice within our office. It wasn't really serving all our client population. The goal had to be that we needed to bring this service to all our clients, or as many as we could. So we have endeavored to grow the program. What that currently looks like is we have grown to a team of 6 lawyers. Those lawyers handle both early engagement with clients, meaning they talk with them at the jail prior to their first court appearance, their arraignment, hopefully 24 to 48 hours before that appearance, and then do the arraignments themselves as a team. Last year, like I said, we engaged 1,300 clients, and we are looking to expand beyond that each year.
Thank you. Well, I think with that, maybe we'll jump into some of the questions that have come in. The first one, I believe, would be for you, Joanna. Paul asks, what were the difference estimates for the likelihoods for conviction and dismissal? You're on mute.
There we go. It wasn't unmuting. I'll actually here's the fund table from the paper, and you can see the treatment on the treated estimates in the last column in column 5 are the results that we've been discussing here today. And you can see the coefficients on case dismissal and conviction. So 36 percentage point increase in case dismissal and a 27 percentage point decrease in the likelihood that the defendant is convicted. You'll also see 23 percentage point reduction in the likelihood of a guilty plea, but it's only marginally significant, so we haven't been highlighting it as a primary finding. But again, in future work, we would really like to dig in and see if that finding is more robust.
Thanks, Gianna. We have another question. Somebody asked, could you talk about how PARR interacts with the other agencies and actors in the process?
Yeah, I think that's a great question. When we set PARR up, we realized that it was important to kind of try and get consensus with the other partners or actors in the criminal justice field in Santa Clara County. So we actually made this proposal to start the PARR program in conjunction with our pretrial services office and the Santa Clara County District Attorney's Office, both of whom strongly support the program. And I can tell you that last fall, Carly presented to the California Committee on the Revision of the Penal Code about perhaps codifying PARR, making it a statutory requirement for all persons charged with crimes to potentially get representation well in advance of their first court appearance. And Carly presented there, in addition, with David Angel from our district attorney's office. And, David really supported the program as well as did his office, because I think that they recognized that providing counsel early made a way for more information to be known about people that were appearing in front of court, so that judges could make what we would call individualized determinations, and that actually improved public safety around those releases. So, I think the great thing about this program is that it enjoys, I think, broad support within the various actors in the criminal justice system.
Carly, you touched on this a little bit, but somebody asked about kind of the bigger policy landscape question and mentioned that there was legislation looking at doing something similar to PARR. But if one of you could talk about a bigger sense of where we're headed with this, is California ahead of the curve? Are other counties looking at this?
Yeah, I think we are ahead of the curve in California. And I can tell you that Carly, a year or two ago, hosted representatives from the public defender's office in Los Angeles. I know that Carly and Megan hosted representatives from the public defender's office in San Diego within the last year. A lot of public defender's offices are looking at this. We've also been partnered with the Office of State Public Defender, the OSPD, to try and spread the word around this. So, there's a lot going on. And the Assembly Bill 1209 that we're talking about, which would codify PARR and make it a statutory right, is currently in appropriations. So it's probably not going to go forward this year, but we're hoping that down the road, this does become a statutory right for all persons charged that are in custody in California.
Thank you, Charlie. This one came in, they said, for Megan or Carly, these are striking results. Why do you think it makes such a big difference?
Answer that. I think it makes such a huge difference because you're taking an individual, and instead of viewing that person as a case number or a booking number, you're spending time getting to know the individual, their life circumstances, what was going on at the time that the charges were brought. You're able to dig in a more individualized way than you could on a large arraignment calendar where you're meeting your clients for the first time in court and developing plans and discussing really personal details right on the spot. So I think the difference is that it just gives more time and dignity to the process.
This person wrote and said, were there any surprises that you had with developing this program, good or bad?
Yeah, there was a thing called the pandemic. So, we had laid out with Carly and Carson, I thought, a very good plan for implementing the program. And we kind of went live with the California Policy Lab in January of 2020. And by March of 2020, we were effectively shut down because we could not gain access to our clients in custody. We tried to do some workarounds, including getting tablets out to the jail at booking. And we did that with some success and some hair-pulling experiences that Carly could address, could talk to. But, we just kind of continue to stay at it and, be nimble and pivot and try and, bring a service which we think is, makes abundant sense to bring this service to clients, because it really is ultimately about wealth disparity. I mean, if you are of money in this community, your attorney is in the jail almost immediately. You are posting bail. If you have bail, you're walking free. An entirely different experience if you are a person of means as opposed to a person that does not have money. And we really wanted to level that playing field for folks, our clients who, for whatever reason, just don't have the resources to hire an individual attorney. We thought we need to kind of bridge that gap.
I'll add another surprise, if I may, which is I didn't know how many people were actually booked every day, because as a kind of boots on the ground arraignment attorney, we arraign maybe, I don't know, 50 in custody people in a day in one of our court buildings across all the courtrooms, but there's 150 people booked into jail. And so when you're a public defender and you are appointed clients on arraignment day, you don't see all the people that were in jail for 2 or 3 days, and either the case is so weak that they weren't charged, or they posted cash bail to get out and delay their court date so that they can be reunited with their family and come to court out of custody. So that really surprised me, just the volume of the churn of people through this system that are invisible to those of us that, you know, work in the courtroom.
Thank you. One more question. Someone said, is there an average PARR participant?
Charlie or Megan, do you want to jump in?
I think there's an average PARR participant. I think that we try to serve as many people as our staffing will allow in a day. Some days, for instance, Mondays following the weekend are so voluminous that maybe we can't get to everyone. But we try to serve all of the indigent in Santa Clara County that get booked into the jail.
I'll also add that we learned how to do a better job by starting. And I think anyone who's thinking of piloting this type of thing, I would urge you to just try it, just start and see what is working and what's not. For example, Charlie Hendrickson really urged us to serve clients that are on parole. And I think as a someone administering a scarce resource, we hesitated to go see someone on parole because we see there's a parole hold and we go, oh, well, maybe we can't get them out of custody. But the urging to broaden the service was really valid, because we learned that the parole agents will often lift the holds if they know what's happening. And so we will commonly reach out and call the parole agents and say, hey, here's what's going on. And then we learn if the client is service connected. Were they participating in programming? You know, some people were doing quite well on parole and then just, you know, were in a stolen car, got arrested for some kind of circumstance that's not really connected to recidivism. So I would say that that is average changes by learning from our client.
I think we had another question come in. They said, do the PARR attorneys just work on meeting with the clients, or do they act as arraignment attorneys as well?
Our team consists of currently 6 attorneys who are on a rotation of doing PARR interviews and arraignments. So if you appear with one of your clients that you did a PARR interview with, that's great. Otherwise, we have a really open dialogue where we talk all day long about the different clients, what's happening. If this agency got back to us before the court date, if that investigator was able to confirm something. And so we aim to be a seamless team where information is being shared at all times.
Thank you. I think those are all the questions that have come in, unless there's anything that any of the panelists want to mention. Well,
can I just say one last thing? I'm just so grateful to have been involved in this effort, and I can't urge enough how important it is to empower younger advocates and voices that are not represented in the system. People like Carson White and fellowship attorneys, like people who are kind of newer to the kind of daily criminal justice grind, are invaluable for brainstorming and issue spotting. And I think it's a recipe for a really successful program to combine like some old timers with some new fresh perspective.
Thank you. Joanna or Megan or Charlie, if you had any concluding thoughts?
No, I just wanted to thank everyone for the partnership. I think, we checked in with Carly every month throughout the pandemic. So it was, great to know, kind of track what was going on with PARR throughout the time, and just really grateful for all the time spent explaining the program to us and the eligibility criteria, and really making the study as strong as it could be. And thank you all for being here and sharing your wisdom with everyone on the call.
You.
Well, with that, thank you all for presenting on this, and thank you all for attending it. Have a good day.